Hello, everybody. Thank you for tuning in today. Welcome to It's Time for More Injury Funding podcast for all who want to learn about legal funding and its significance in the personal injury, workers' compensation, right-share injuries, trucking law, and all other types of law practice domains. I'm your host, Laura, founder and CEO of More Injury Funding, the legal funding counselors for passion with law, for law, medicine, legal funding, and heart for all separating individuals. Today's episode is one that I'm especially excited about. Not just because of the legal insight, but because of the lived experience and leadership behind it. I'm joined by Rose Harper, a personal injury trial attorney with Rose Harper Law Firm, licensed in Pennsylvania, New Jersey, and New York, whose practice gives her a rare front row view into how dramatically state laws and insurance rules can impact injured people's lives. We will be diving into issues most accident victims and frankly many lawyers don't fully understand until it's too late. Policy limits disclosure, PIP or PIP, and UIM, which we'll talk about in just a moment, coverage, and how the auto insurance choices you make years before a crash accident can define outcome of your actual case. Rose also brings a deep personal perspective, having been involved in a few actually car accidents herself. Rose also brings a deeply personal experience. Having been involved in a few car accidents herself, she understands the firsthand personal, emotional, and financial toll these events take. And beyond a courtroom, Rose is here actually with us in Atlanta today, filming for Women in Leadership with Betty Aquino tomorrow, a powerful project led, like I mentioned, by Betty, highlighting women who lead with purpose, resilience, and impact. And so this conversation today is about fairness, transparency, power, and what it really means to advocate for injured people. Stay tuned till the end, because as you know, we have a fun pop-up question coming up. So let's start now. Welcome again to It's Time for More Injury Funding podcast, Rose.
Yeah, thank you so much for having me. I'm really excited to talk about some of these topics because, a lot of people don't realize how important the decision-making process is when you choose your own auto policy. So hopefully that will become clear as we talk about some of these issues.
So you are licensed in 3 states, which is actually pretty rare. And I'm very, very proud of you because of that. So that is Pennsylvania, New Jersey, and New York. How does practicing across these jurisdictions change the way you think about strategy, advocacy, and client expectations?
The location where your accident occurred will determine the venue. There are some other factors as well, so you can have a choice of venue on some occasions, like it could be the county where the defendant lives. They could also be the county where the plaintiff lives, but the location, essentially the state where your accident happened, that's where your case is going to be venued. So if your accident happened in Pennsylvania, but you live in New York because you were just going to Hershey with your kids, then your case is going to be venued in Pennsylvania. So I'm originally from New York. I went to law school in New Jersey, and now I live in Pennsylvania. So, and it's really like across those 3 states, everyone is constantly going back and forth. People live in one state, work in another, so you're going there daily. So, people's accidents can happen all over, even though they live somewhere else. And it does impact your case. Each venue is going to have different rules of civil procedures, even different statutes of limitations, meaning the time that you have to filing the lawsuit. And they have a lot of different insurers requirements as well. So each state is going to have a different, policy limit requirement. It varies greatly. So each state, you really want to make sure that you have an attorney license in that state. That's definitely key. And is actively practicing. So, I initially started out my legal career in New York. Then I spent time litigating in New Jersey, and now I'm also in Pennsylvania. So understanding the rules of the law, the civil procedure. Also, each state has different rules with regard to insurance. For example, in New Jersey, if you personally, say, for example, you had insurance, auto insurance on your vehicle, and you didn't realize that it lapsed. So you forgot to make a payment, your auto payment got turned off somehow, and the day of your accident, you didn't have an active policy on your vehicle, and you got into the accident. It was someone else's fault that the accident happened. Because you didn't have an active insurance policy on the date of your accident in New Jersey, you cannot bring a claim against somebody else that hit you.
That's so unfair. So let's say if something happened to my credit card, let's say if I had to change the card or somebody stole it, then I had to call the bank, had to close the card, and it literally took 2 days for my new card to come in, even though I was religiously paying my policy for years, let's say 20 years. Does that mean I will not be able to bring the claim?
Well, it depends on the insurance company as well, because some policies will have like a 7-day grace period or a 14-day grace period, something like that. So you may still be able to get coverage, but if they deny coverage because there was no active policy on the day of the accident, because a lot of times what happens is the insurance companies, like, they're trying to protect their bottom line too. So once they know that you were in a car accident, they're going to try to disclaim coverage for any reason they possibly can. So a lot of times they won't let you go back and make that payment to get your policy active on the day of the accident. So that's like a big difference between New Jersey versus New York and Pennsylvania. You can still potentially bring that claim even if your policy wasn't active on the day of the accident. And there's a lot of other, really interesting factors, at play. But even within the same state, so you could have a case that's venued in Bronx, New York, same exact injury, same case in the Bronx versus in Albany. Those cases are going to be valued very differently because the venue's different, the cost of living in the city is higher, versus upstate, things like that. So that all goes into the strategy, the timing, and how you're going to proceed with the case.
Very, very valuable information. Hopefully everybody's taking note there and living in those 3 states. So Rose, one major difference between these 3 states we just talked about is policy limits disclosure. Can you explain the rule in Pennsylvania versus New York and New Jersey for our listeners and viewers who may not practice in all 3 states?
Yeah, definitely. So an important part of any case, any auto accident case, is you want to find out what the policy limits are that cover the accident. But each state has different rules with regard to the obligation to offer up that information. So in New York and New Jersey, insurance carriers are obligated to produce their policy limits on the defendant liable driver's policy pre-litigation under certain circumstances. So, like, for example, in New York, you'd have to furnish them with proof that they're insured was involved in the incident, that the policy applies to this accident. They can't just be producing policy limits to random people. Mm-hmm. So you want to produce the police report. There's other information you're going to have to produce. New Jersey requires that the plaintiff had insurance, auto insurance, that they were a driver. So they had to produce proof that they had insurance coverage on the day of the accident before they're going to produce the defendants. And that's totally different from Pennsylvania. So Pennsylvania, actually, before litigation. So this is just like a pre-litigation. Nothing's been filed in the court yet. We're just going back and forth, basically notifying the insurance companies that, someone's been injured in this accident. We feel like your insured is liable for the accident. They do not have an affirmative obligation in Pennsylvania to produce their policy limits pre-litigation. So, of course, you can file the lawsuit and get the policy limits during discovery. That's a discoverable, document, policy limit, disclosure. But before litigation, the truth is that maybe 80% of personal injury cases are going to settle pre-litigation. So the cases are going to litigation because we don't want to overburden the court system either, right? Some people don't realize that we have a duty to actually attempt to settle these cases before we even file in court. Because, it's unfair if we're just automatically filing everything. It burdens the judges, the juries. We want to try to, if we can resolve things amicably without involving the court system, that's more ideal for our society.
Absolutely. That's true.
And our judicial system, so you don't overburden the system. So the cases that are proceedings ask for jury intervention, for a judge's intervention, those should only be cases where there's a true issue of fact that needs to be tried. So there's, we totally disagree on liability or damages or something like that. So if you have a case that you can settle pre-litigation because liability is clear, you have the damages, but in Pennsylvania, they don't have to disclose their policy limit before you file that lawsuit. So that creates a little hiccup in the cost.
Oh, yes, quite a big hiccup, I would say. All right, let's move to our next question. How does the lack of required pre-litigation policy limit disclosure in Pennsylvania affect how you evaluate cases? Because I know you reside in Pennsylvania, is that correct? And how you like I said, how you evaluate cases, how you advise your clients, and decide whether to file suit at all.
So when you first get a case in Pennsylvania, you can always look to your own clients' uninsured motorist coverage and underinsured motorist coverage. So that's also another distinction. New York and New Jersey, say, for example, if a defendant has $25,000 bodily injury insurance coverage and you yourself have, $50,000 in underinsured motorist coverage, you can pursue the additional 25 from your policy. So my $50,000 policy in New York and New Jersey would be offset by the defendant's 25. So I can get 25 from defendant, 25 from my own policy. Pennsylvania, there's no offset requirements. You can actually get in addition to. So even though the defendant pre-litigation in Pennsylvania does not have to disclose their policy limits, if I know that my client at least had the $50,000 policy limit or something like that, in uninsured or underinsured motorist coverage, I can pursue that potentially on top of whatever the defendant's policy limits are. But essentially, the Pennsylvania process requires a much closer and tighter relationship between the attorney and the claim adjuster, in my opinion, because you want to be really careful. Also, Pennsylvania, the PIP cover is really low. It's like minimum, you only have to have $5,000.
So, which is similar to Florida. I believe they have 10.
Okay, yeah. So, you're covering an MRI and, that's basically it. So you want to be really careful because I don't want my client racking up a lot of medical leaves on their case and then come to find out the defendant only has $25,000 policy limit and my client got a surgery. That's not good. So essentially you have to constantly, first of all, if it's a catastrophic case, the insurance company needs to be providing the policy limits in Pennsylvania pre-litigation, in my opinion, or it's in the file. You have to file the case. But if it's not that, and maybe your client has soft tissue injuries and you're like, well, let's see, what the extent of the injuries even are yet. They want to get treatment. We're not sure where this was going to go anyway. Just updating the claim adjuster to let them know, like, hey, I'm getting concerned about the medical liens here. My client just got an injection done. There's a surgery recommendation. I don't want my client having $100,000 medical lien on a surgery and you have a $50,000 policy with them. So opening up those conversations and making sure that, there's an understanding that as the treatment progresses, that you're going to be seeking out those policy limits even pre-litigation, because I think it's unfair. If you don't have access to that information and you're racking up these medical liens, I don't think that's fair. I don't think that people should have those medical liens and not be aware that the defendant doesn't have enough coverage to pay for the treatment that they need. I think there should be disclosure pre-litigation so that everyone understands, look, this is the most amount of money possible. Because even if they provide the policy limits, even if an insurance policy covers a car accident case, $1 million bodily injury, that doesn't mean that there's going to be $1 million worth of damage. It just means that there's up to that amount to cover the damages. So, you could have $1 million policy case, but, by God's grace, everyone walked away with just some soft tissue, it is some PT, and that was it. So that case is not going to sell for $1 million, So I don't think that there is necessarily a detriment to producing a policy limits pre-litigation. I think it helps everyone be on the same playing field. That evens things out and really helps people to make informed decisions about whether or not they're, going to take on this medical lien debt or maybe wait and see if they can get better with alternative medicine or more conservative treatment.
I appreciate that. From your perspective, Rose, does non-disclosure of policy limits create an imbalance between injured plaintiffs and insurance carriers? Why or why not?
I think it does, because what happens is, I was kind of touching on this already, but, for an injured plaintiff who's seeking treatment, they didn't cause the accident. They were just living their life, and because of someone else's negligence, they're now injured. And they're going to potentially have medical bills, based upon the treatment they need to get better. And I think it's unfair if the insurance company knows that there's not enough coverage here and my client, need the surgery and everything else, I think they should immediately produce that information.
How do insurance companies behave differently in states where disclosure is required versus states where it's not? And how should plaintiff attorneys anticipate that?
Yeah, so for example, I know in Europe and New Jersey, I'm going to have the policy limits immediately, unless they're denying liability. So that's another factor. So if the insurance company is denying liability on the behalf of their insured, then they're not going to produce the insurance policy limits, even in Europe and New Jersey. They're just going to say, hey, we're denying liability. You're going to have to file a lawsuit no matter what anyway. So then in that case, you'll just file. In Pennsylvania, it's very similar. If I know that I have, if your client immediately went from the accident scene in an ambulance and got emergency surgery, that type of case, and you need the insurance policy limits immediately, and if they don't produce them, you're going to have to file a lawsuit immediately, because you already know that there's a dispute occurring, because they should be producing that information up front. If it's not that, and you get more of a soft tissue case, you would still just open up the door of conversation and keep them up to date, because you don't want your client going for a surgery on this $25,000 policy limit case, unless they understand that their medical liens might exceed the coverage that can even pay them.
That totally makes sense. Many consumers, unfortunately, don't realize that who they choose as their auto insurer can significantly impact their injury case. What should people understand before they ever need a lawyer? Hopefully never, but did they do?
Yeah, hopefully it's I work at an insurer where it's hopefully you don't need me, that you don't available. But yeah, so I think choosing the insurance company that you insure yourself with, your own auto insurance policy, is really important. Not only the company, but the policy limits and the terms that you're choosing. So I think a lot of times people get insurance maybe when they're in college, just the first time you're getting your own auto policy, or your first job after college, and they're really young and you have no assets anyway, so you're just getting the cheapest policy, right? Because you need something, but you don't really care about them. And you think you're invincible and you're young. And then what happens is people forget. They forget to revisit their auto insurance coverage. But it's a huge issue. You want to make sure that you're working with a company, one, that is responsive. I can't get over these companies. It's my own client's insurance and I can't get a hold of anybody. And they're not getting back to me for a month. And my client needs their car fixed. They need medical treatment. We need to know the policy limits. We need information from them. So you want a company that's actually active, responsive, that's going to provide you with the coverage you need to help you. So I think that's another misconception people have, is I'm getting an auto insurance policy in case someone else sues me. Actually, yes, you are, but you're also getting it to protect yourself. Like I talked about with the uninsured motorist coverage. So if somebody hits you and they have no insurance, your own policy can actually pay you for your pain, your suffering, your injuries, all of that. And then the underinsured motorist coverage, super important, because you want to make sure if they have a very limited policy limit, that your insurance policy can also cover you. And you want to think about it, would you need lost wages? That's something that your own auto insurance can pay you, lost wages, car rentals, reimburse you for travel to and from the doctor. These are all things you want to ask when you're getting your insurance policy.
They're smart. Actually, I had quite a few attorneys on my podcast talking specifically about that, about more, I would say, applicable to Georgia. But nobody mentioned these very good questions. So take notes, please. How often do you see clients whose cases are capped or compromised simply because of the policy limits they selected years earlier without realizing the consequences? And, we touched on that, but
It's always tragic, honestly. I saw a case with a woman who was really seriously undertreated, a surgery to her neck, the cervical discectomy, and there was only a $15,000 policy limit covering that.
so sad.
Yeah, it was really, really bad, and she also didn't have health insurance. So she was in a really bad place. We were able to connect her with a hospital that had grants and some nonprofits that donated. But she was not to be compensated for her cancer operating, and the amount of compensation she really deserves for that accident. Unfortunately, because anyone driving around with a $15,000 policy limit doesn't have assets, they have nothing to their name. People, the way people live their lives is just really crazy.
Day to day.
Yeah, exactly.
For non-lawyers listening and watching this, can you break down the PIP and UIM coverage and explain why these provisions can make or break an injury claim? And that it was specifically what they stand for, PIP and UIM.
Mm-hmm. So in New York, it's called no fault, and then in New Jersey and Pennsylvania, PIP, personal injury protection. But essentially what they all are, no fault or PIP, is your medical coverage under your own auto insurance policy. And also I would add, in all those states, if you, say for example, you're a pedestrian that's hit, you're I don't even have a driver's license, I don't own a car, I don't have my own auto insurance policy. So in those states, there's also programs set up to provide med pay coverage for someone who doesn't have auto insurance but needs medical treatment after an accident. So that's a really important thing to consider. But if you do have your own auto insurance, you want to look at your PIP coverage, because if you have a very low policy limit, then your medical treatment is going to get covered up to that policy limit, your PIP limit, your no phone limit. So, and that's something you can negotiate when you're purchasing your, insurance coverage. You won't realize that. So you want to increase it to an amount that would actually cover the medical bills associated with a surgery, for example, or something like that. So, you want to have a $50,000, $100,000 PIP covers women if you can. Obviously, you want to look at how much is that going to impact the cost of your policy. Does it make sense for you? But essentially, in any auto accident case, you go through your own auto insurance to cover your medical treatment. You use your PIP, your no fault. And then once that's exhausted, then you could potentially use your health insurance, or you would treat on a lien. But your health insurance is going to assert a lien as well, plus your medical liens, obviously. Those all have to be paid back from your settlement, versus PIP or no fault through your own auto insurance policy. Those don't have to get paid back. So very important to your case, because you're leaving, you're already purchasing this insurance coverage to protect you. And that's a part of the protection. So why wouldn't you want, the best and not possible? Because then when you sell your case, you're not having to pay out as much money to the medical bill. Hopefully, you can actually properly be compensated for your pain and your suffering. Something that's to know.
Yes. And so you mentioned when we spoke earlier that you've been involved in a few accidents. How many is that total?
Oh, I'm going to go on the record on.
I guess get into a few up in a jump in the join a few. No, so there's been a few. I know, but probably two or so. So we haven't personally experienced a few car accidents yourself. How has that lived experience changed the way you communicate with clients, with your clients? How do you evaluate case value and advocate for the long-term impact of injuries beyond what shows up in medical records?
Yeah, I think the biggest thing that I took away is, when you have an accident, you're initially in shock. You're in total shock, your adrenaline's running, and you're also in denial. You're trying to just think, you're trying to downplay, oh, wasn't that bad, or I'm okay, and you're just trying to you're thinking of so many different things and everything's coming at you at once because you're going to have to, well, like I was younger, so it's like, I'm going to tell my parents. I'm going to have
That's the biggest fear for young people, Rush.
have to tell the insurance company, to the top of the police. There's a lot to navigate. And actually, my oldest son was in a car accident not too long ago. Yeah, he's, college student, and he thought the car in front of him was merged already, and he turned to make sure no one was coming, and he went forward and had an accident. And, actually getting to see him navigate that process himself with talking to the police, to getting with our insurance companies, explaining to them what happens. And, at the end of the day, he had a responsibility to make sure that he didn't impact the car in front of him, right? But going through the financial issue, like we talked about, there's an impact there because, like, our insurance company, wanted to, 10x what I was paying for auto insurers that next year. But we were able to find a different company, change companies, and, go with a company that, looked at our entire track record, not just that one issue, and, have us pay an appropriate amount for the liability risks of him being on the insurance. So that's something I speak to my clients about as well. Like, if they're worried, like, oh, because a lot of times people are concerned, like, well, if I report this to my own insurance, I didn't cause this accident, they're going to hike up my, how much I'm paying for auto insurance. But, the thing is, like, you can price shop and you can go to a broker who can, find a better policy for you and keep your prices down. So I wouldn't say don't tell your insurance company because of that. And in fact, if you fail to tell them you were in an accident and then they find out you were, that could be a bigger problem. So you definitely want to report, any of these things. And the other thing I would say is, like, the emotional impact. There's so much that you're going through. I think people oftentimes forget that there is a real emotional toll, and sometimes the anxiety, like in PTSD or things like that, can come up. But a lot of times people don't even really know to express those symptoms or talk about it. So I think just being aware that if any of those things are coming up, or depression or something because of the accident, to make sure you're reporting that to your medical provider, of course, but also to your lawyer, so that they can make sure that that's included in your claim.
Rose, thank you so much again for being with us today and for sharing your insights, experience, and advocacy. This conversation showed how insurance rules and choices shape justice long before a case begins. And as always, we have a very fun pop-up question for you. You ready, my dear? Okay. How do you, Rose, define success? What does that mean to you personally? Is it through results, through impact, recognition, or something totally different?
I would say living in my God-given purpose. I feel like God gave me certain skill sets and talents, and I use those to help people every day, which I'm thrilled about. And doing so with integrity, and that's success for me.
I love it. Again, that was Rose Harper, a personal injury trial, a lawyer with Rose Harper Law Firm, licensed in 3 states, Pennsylvania, New Jersey, and New York.